What's up, everybody? Happy Monday morning. It was an interesting weekend. We were coming off a lot of the Ocean Gate stuff, a lot of questions about that, going on some other shows and stuff, talking about the waiver and, what happens if lawsuits are filed and answering those kinds of questions. But this is one of the probably top 5 most requested videos that I've gotten since starting to do YouTube a couple years ago. And it was when we had another huge document dump here in the Kohberger case. And I think there was, 10 or 15 things filed. And so what we're probably going to do, just logistically speaking and timing wise, is we will probably split it up into 2 videos. And this morning, I'll get through as much as I can, obviously, this morning, but I am going to look at the docket, explain the ones that are quick to explain, and then kind of break it up into 2 parts. And today's part is going to focus on the motion to compel, the DNA evidence, the experts, the defense's explanation of the case and the potential issues in the case and what that means and whether or not that is, I'm not going to say evidence because we know by now that what lawyers say, especially in their filings, is not evidence, but what that's evidence of, right? Do defense attorneys do this with an inkling, with just a gut feeling? Do they do this when they have evidence of their own? Do they do this when they're sure? What are some of the reasons and motivations behind doing it? Because there are a couple different reasons to do this. And one of the things about being a lawyer and litigating cases is you have to know how to use leverage and use the tools in your toolbox. And when you feel like you have something, you have to use it appropriately and ethically in order to get what you want or need in a case. So we'll talk about that as we go through exactly why and how things were said in these documents. And then part 2, probably tomorrow morning or one other morning this week, we will talk about the new non-dissemination order. We will talk about cameras in the courtroom. We will talk about the judge's decisions for Shannon Gray and for the media. Those are kind of 2 good breaking points, I feel like, and not to get lost in one overly long, rambling, boring video. Hopefully cutting it into 2 will keep the energy up, keep the questions focused, and help us learn how we feel and think about each of these situations. So today we are going to focus on that DNA evidence. Hit the like button if you haven't already. And share this with other people that you may be talking to on Twitter, on Instagram, on Reddit, on whatever it is that you're talking to people, Discord, about this case. A lot of people asked me what my thoughts were. There are so many documents. It was impossible for me to kind of just summarize them in a tweet. So that's why I wanted to make 2 videos just kind of talking about what is happening here. Some of the documents were simply a motion to shorten the time that the judge agreed to. And so there are orders to shorten time. There are motions to shorten time. We're not going to get into any of those today. I don't think those are anything that you all care to know about. And it was to shorten the time to hear the defendant's motions to compel. So I think we just can bypass those. And what the big focus is going to be today is the defendant's 3rd motion to compel, which I believe the hearing is tomorrow or at some point this week. So that's where we're going to start. And then we're going to get into the experts and Ann Taylor and what they say and how it's responding to the state and kind of why we are where we are and what it means. Does this mean there is so much reasonable doubt that the state's going to have to drop the case? Does this mean the state is hiding something? Does this mean the state has something big that they don't want to turn over to the defense? What does this all mean? And to help us, we are going to go through a bunch of the documents. We're not going to read every word of every one of these documents. I think it's like hundreds of pages, but I will summarize the parts that we do not read together. All right, let me see where we're going to start. All right, so first is the declaration of Ann C. Taylor in support of the defendant's 3rd motion to compel. So every jurisdiction does things a little bit differently. We wouldn't really do stuff like this. Let me see. Oh, I don't have my old, or my new, I should say, custom format here that John made. Oh, yes, I do. There we go. So we wouldn't do something like this here in Florida. But Basically, it's just telling the court, this is legit. We need this stuff. Here's what we have. We would reserve this for the actual hearing time where we could just make these arguments to the court and say, Judge, this is what the state's given us. This is what they haven't given us. This is why we think we need it, right? And we would do most of that in the actual hearing. They put some of it in writing here. So this reads more like an oral argument, which I think is fine. I actually have heard some stuff about the writing styles, and people have asked me, do you write like this? How are your motions written? 99% of the way I write motions is as stiff and respectful as possible. It's just kind of, I don't know why, that's just kind of the style I put things in writing. Now, my emails, obviously the way that I speak, the way that I argue, the way that I talk in trial is exactly like this. I try to be exactly like this when I'm in trial. If I'm explaining something to a jury, I want to act like I'm explaining it to any of you all, to my friends, to my family, to non-lawyers. That's how I try to speak in actual trial when there's a jury involved. When it's a document that's going on the record publicly and to a judge and to the other side, I just always err on the side of using legalese, doing it the way we were taught in law school. You don't have to do it that way. There's nothing wrong with being more lax. And I will say, you get less, I don't know if less professional has a negative connotation, but I mean, you get less stiff, I'll call it. The more you work on a case, if it's a high profile case, if there's tons of motions going back and forth, if you develop a rapport, either good or bad with the defense attorneys, then that can change kind of the verbiage that you have in your motions. Okay. So declaration in support of the defendant's third motion to compel. Ann Taylor says this: counsel for the defendant filed a specific request for discovery related to DNA. In this case, titled Defendant's Third Supplemental Request for Discovery. The state filed a specific response to that request. After reviewing the materials provided, the following remains to be discovered. So what is she doing? She is saying, oh, yeah, it was my, is that better? It was my MacBook mic. Somebody just said, turn your mic on. All right. So now my actual mic is on, the one that you can actually see. It's not just for show anymore. So hopefully that sounds better than just my Mac mic. Okay. So what she's doing is she's saying, Judge, they said they've given us some stuff. So we went back, looked at the stuff they gave us, and here is what they did give us. Here's what we still don't have, and here's why we need it. This is a little bit of a weird setup here. I can't see the tops of my comments, which is annoying. There we go. All right. Thank you, Ashley. So I fixed the mic. Okay. Back to the document. All right. So here's what we have. Here's what we don't have. The state has provided information related to this request for the seized item, the knife sheath only. The defense has requested all DNA profiles. So there's a difference here. The state is only providing what they found on the knife sheath, the touch DNA that they've connected to Brian Kohberger. But what the defense has asked for, Judge, is all DNA profiles. So the question before the court is, what is the defense entitled to? Just the knife sheath because the state says so and because the state says, trust us, there's no DNA that you need on anything else? Or do we get what we asked for, Judge? Because I think all DNA could lead to relevant material. And that's what discovery is for. It doesn't mean other DNA is going to come in at trial. We always have to remember that. Just because one side or the other is asking for something in discovery does not mean it's going to come in at trial. But they could still get it in discovery. And that's what we're asking for. All DNA profiles, including 3 additional unidentified male DNA profiles developed during the course of law enforcement investigation. This information has not been supplied. So there are some things that we don't know, right? And we've been saying that the whole time. When we're not the lawyers on the case, we're not a juror on a case, we're not a party to a case, there are always going to be things we just do not know. And so they have dropped a bombshell, if you want to call it, or a surprise on us that there are 3 other unidentified male DNAs there, profiles there. That could mean absolutely nothing. Or it could lead us to a potential suspect the potential real person who did this, as Brian Kohberger has maintained his innocence at this point. So those are absolutely things that could reasonably lead to discoverable material, which is the standard in whether or not something's discoverable. So that's what the state, or that's what the defense is asking for, and that's what they say the state has not turned over. It could be people that were at parties and they were friends and they ruled them out. It could be the DoorDash guy, which they've ruled out. It could be all sorts of things that don't mean anything. That could be nothing burgers. But the defense has the right to do that investigation as well. And they also have the right to know, what did the state do to rule out the DoorDash guy? We don't just take, as the public, the law enforcement saying, we interviewed him, he's good. No, we want to see that interview. We want to see what DoorDash guy said. We want to see where his car went. We want to see his DNA profile. And you have to do that. That's important. Request 6, communications. The state has not provided all emails, text messages, electronic messages, or other messages and conversations regarding biological testing in this investigation. When Ann Taylor makes comments like this, I am willing to bet that she has looked through all the documents and she fully believes that this is true, that she has not been provided all the emails, text messages, etc. Now, where the rub may come and what the judge may have to decide, what is the definition of all emails, texts, electronic messages? Because the judge may say, you don't get all of them. You don't get between, a law enforcement officer and one of their superiors that includes another case or something. There can be certain text messages that could be considered conversations regarding biological testing. How do you know, if you're the defense attorney, whether or not you have all of them, right? Maybe you can tell there's one missing in a chain, but that's going to be the discussion, is what does all mean and what are you actually specifically looking for? And this is one of the very difficult parts about being a defense attorney. The state holds all the chips. They hold all the cards. They know what there is and what there's not. And you as the defense attorney sometimes just need to make sure you're asking for everything so nothing gets lost by way of a definition or a technicality. Request 9 and 10. Unexpected results and corrective actions. This request has been partially complied with. However, the response lacks the full scope of the request. 6 months before and 6 months after testing related to this investigation is what they're looking for. Further information relating to all lab personnel has not been provided. And again, based on the state's motion, that's not something they've agreed to provide. They don't think that's discoverable. The judge is going to have to do what judges do, make a decision. Part of the third supplemental request for discovery is related to the genetic genealogy testing. The state has objected to this request in its entirety and has filed a motion for a protective order. Counsel for Mr. Kohberger requests that this court consider the contemporaneous objection to the state's motion and declarations in support of the motion to compel. We're going to get there. We're about to get, those are the documents we're going to read, basically responding to the state's protective order. They think it's proper, obviously, and the discovery is necessary. Counsel for Mr. Kohberger has reviewed the materials provided in this case regarding the DNA testing, laboratory reports, bench notes, and photographs. Further, experts in the field of genetic genealogy and DNA have consulted and offered information and guidance. We are going to read some of that. The state acknowledges it used genetic genealogy testing in this case, but claims it does not have to produce the records in the specific request for discovery. The defense disagrees. And when you have something as simple as that, state says this and we disagree, judge is going to have to make a call. Now, what you can do as the defense attorney is bring evidence and bring testimony to the table, which is what they do with these experts here in a second. Counsel has learned through consultation with experts, which is, by the way, how defense counsel learns a lot in these cases. We are not all experts in genetic genealogy testing. We're not experts in weapons, as you saw in the Murdoch case. We're not experts in gangs, as you see in the Melly case. We're not experts in psychiatric testing, as you see in Letitia Stalk and other cases. We're not experts in certain religions, which you'll see come in like the Lori Vallow case. But what makes a good lawyer great is being an expert lawyer and being able to learn and become an expert in whatever field you have that trial in. And the way you do it is we don't go to whatever, Johns Hopkins School of Medicine to learn about medicine. No, we choose the best experts. We talk through the case with those experts. We learn what the pressure points are and where our arguments come from, what their arguments look like, how to combat them, how to cross-examine these witnesses, how to best explain it to a jury in a way they can understand. What are the regulations? What are the rules? I mean, we've become experts in so many different things. I remember one of the first trials, that was a huge federal criminal win for us, which is very rare. Just to win in federal court in a criminal case. We've gotten a lot of cases thrown out. Winning it at trial, those wins feel great because you literally have the FBI, the federal government against you, not just state, law enforcement, things like that. But it was a Medicare fraud case. And they said that this doctor that we represented was fraudulently billing Medicare and stealing money from the government, which obviously they don't like. It's one thing if there's just a victim. It's another thing when the government's the victim. But we became experts in the statutes and rules on how you can bill Medicare and Medicaid, when you can, when you can't, who you can have bill under you. You have to learn that stuff. We've had shipping cases and we've had burning of oils and lead and selling receipts and things like that. I mean, there's all sorts of things that you have to become an expert on. This is how you do it. You use the expert to teach you whatever is going on in this case. And one of the big things in this case is obviously the DNA testing. All right. That was a big tangent. Sorry. The use of genetic genealogy database do not necessarily lead to a single individual as a potential suspect, and the reports of these searches often reference multiple individuals for further investigation and DNA testing, which, by the way, doesn't mean somebody else did it. It just means if they said it could be Brian Kohberger or it could be John Smith or it could be Jim Jones, did you investigate John Smith and Jim Jones? How did you rule them out? And if they did, they probably won't come in at trial. If they did nothing, like we've heard on the Melly case, that there were some suspects that they didn't do anything on, they're going to come in, as the defense is going to argue and point the finger at them. In fact, the state acknowledges such in its motion for protective order when it acknowledges hundreds of relatives. The testing conducted by the private lab is completely different in nature than the testing done by forensic labs. Genetic genealogy labs do not generate a profile in the same way that a forensic lab does. And there cannot be a direct comparison between the data obtained, in this case by the Idaho State Forensic Crime Lab, and the private lab. The tests used by private labs are either SNP, single nucleoid polymorphisms, or whole genome sequencing. These tests are similar to the methods used by commercial services like 23andMe and Ancestry.com. Based upon information from experts in the field, I have learned that once a genetic genealogy profile is created and the testing by the private lab is completed, the profile is uploaded to a database that contains similar data from other individuals. Once the genetic genealogy profile is uploaded, the profile is compared within the database and relatives are identified. It is my understanding that once possible relatives have been identified, their identities are used to construct a family tree to identify possible suspects using public records and, in some instances, contacting individuals for further family information. This process leads to a pool of individuals rather than one specific individual. The possibility of other relatives who might be similar to Mr. Kohberger is extremely important to the defense in this case. This is exactly what we were saying when we initially read the state's protective order. We understand what you're saying, state, but we need that information to make sure that it wasn't a relative of Mr. Kohberger's, that it didn't point the finger to somebody else that could have done it, or that there's some kind of proof did it. We need to understand, what did you do? Who did it match? That's absolutely important, and I would just be shocked if they don't get more information on this. The process used in this method of identification may be extremely important to Mr. Kohberger's defense, and the reason they're saying maybe is because it may not be, but discovery is the purpose, and point of discovery is to figure out whether or not it is. The trial is where it should only come in if it is not maybe. The timing and steps utilized are extremely important to Kohberger's case investigation and defense. I've reviewed a copy of the Idaho State Police announcement dated July 28, 2021, that the Idaho State Police Forensic Services Laboratory secured a grant to fund genetic genealogy testing for unsolved Idaho cases. And it's attached. The U.S. DOJ issued its interim policy for forensic genetic genealogy DNA analysis and search in 2019. The policy describes the process that law enforcement engages in during these searches and the results and limitations of the method. The identified individuals are one or more genetic associations. That means that the donor of the forensic or reference sample may be related to a service user, which may require additional investigative work and testing. If a suspect is identified, the agency is required to retain all FGG profiles, account information, and data for potential use during prosecution and subsequent judicial proceedings. A new collaborative national technology validation and implementation collaborative was established in 2022. The purpose is to collaborate and formulate methods and policy for labs and law enforcement to establish forensic investigative genetic genealogy programs. This collaborative contributed to a forensic science journal. The publication includes reference to aforementioned DOJ policy. Of particular note is the policy of release of information in accordance with the rules of discovery. I am aware of specific news reports in this case regarding Mr. Kohberger's DNA as published by the New York Times on June 11, 2023, that, quote, FBI personnel worked with the profile that Othram had produced, spending days building out a family tree that began with distant relatives. We're about to find out why that's important. The New York Times sources have more information than the state has disclosed to the defense. So some FBI leak, and this is in June, has more info than we even have, that there's this family tree with distant relatives. Who are those distant relatives? How did we get to Brian Kohberger? I mean, we know kind of how they got there, obviously, with the matched DNA, but still. This New York Times article generated intense media coverage and interest, the scope of which is explained in the TrueScope report attached as Exhibit D. In addition, Mr. Kohberger's defense team has discussed the use of statistics in this type of case with experts who have informed me that the manner of identifying Mr. Kohberger via this type of search may have significant impacts on the statistical analysis of the CODIS profile generated by the Idaho State Police. Without access to the actual genetic genealogy search methods and results, it is impossible for qualified experts to address this issue. More on that later. Counsel for Mr. Kohberger notes that the state utilized a statistical analysis number to claim a high likelihood of match between DNA on the sheath and that of Mr. Kohberger. The state, by its own admission, has taken a number of steps to identify Mr. Kohberger as a match. The statistical probability is not an absolute. The size of the comparison sample and the nature of the search are important to ascertain the conclusion bias. Now, the 3.5 octillion times more likely is exactly what she's describing here. The statistical probability that they, pick a big number, basically. Mr. Kohberger has a right to effective assistance of counsel. He has a right to confront evidence. Counsel must undertake a thorough investigation of all parts of the case the state brings against Mr. Kohberger. As such, the genetic genealogy investigation and process is necessary for the defense team to do its job. That last paragraph is what we call some leverage and pressure that we want to make sure we protect his Sixth Amendment rights. He needs to have a fair trial and he needs to have competent counsel. We need to make sure that that is intact. Because if it's not, there's going to be an appeal and we're going to do this all over again. That's what we really want to avoid. All right. So she references experts multiple times. And we're about to get to a couple declarations of experts. We're going to skip the part where they give their huge background and resume. They're both very qualified, went to great schools, things like that. And we're also going to skip some of their explanation of what this is, this IgG and genealogy testing and how it works. But we're going to get down to a couple points of their analysis that are going to be used here. Welcome to the new members. But it's important to remember why these expert declarations are even here. Welcome, Larissa and Robin. Thank you, Elise. The reason that they have submitted Ann Taylor's declaration, or her argument, we can call it, and these expert reports is so the judge can use them in making his decision. And sometimes lawyers can't just say, we need this stuff, judge. This is going to be important to our defense. But it can add to that if you have an expert saying these specific things are very important and we need these things produced by the state, or we will not be able to provide expert testimony as part of Brian Kohberger's defense team. And if we cannot provide expert testimony, that is not a fair trial for Brian Kohberger, because we need that info to provide the testimony to give him an adequate defense and a competent defense. And if he loses, he loses. But if you take all that away from us, just because the state doesn't want us to see their DNA testing and how they did it and what sites they used and how the family tree was started and how they got to Kohberger, well, now we're opening up ourselves for potential appeal. Okay. Does law enforcement often rely on verbal communication to avoid creating documents to keep the investigation under wraps? Yes, but not just law enforcement. Lawyers will do that sometimes with other lawyers, with experts, don't have reports, don't have documents. Now, you can get into discussions between lawyers and experts sometimes, but verbal communication is used all the time in litigation because it doesn't go down on a document that you have to produce. So this is not really that unusual. Sonia, Peter, is there any scenario you can see where the DNA on the sheath will be inadmissible? Yes. Now, hold on. I said yes too quickly where people are going to run with that. I think it's going to end up being admissible. I think it is going to come into trial. I think it is potentially going to be the single biggest piece of evidence. Now, defense attorneys are going to be able to attack that. Experts are going to be able to try to invalidate that and make it not seem like a big deal. But if a prosecutor can make the argument that his DNA is on the sheath, no other connections to anybody else, and then they get into the cell phone in the car and stuff like that, it's a huge piece of evidence. But there have absolutely been cases where touch DNA has been thrown out completely because of the lack of reliability, the transfer DNA element, which I'm sure we're going to hear more about as the case continues. So I think, yes, it is possible, but you're not going to hear me say things are impossible very often. Peter, does it matter how they got the DNA? So this is a broad question, and the answer is yes, because if they finagled some way or they touched something and then they touched that sheath and that's how they got the DNA, that's important, number one. Number two, how they connected it to Brian Kohberger is important, because if it's connected to a distant cousin that also goes to University of Idaho, we need to see, did he have an opportunity and ability to commit this crime? Did he have any connection to the victims? So that is really important. Anna, question, how can you find someone that's a match utilizing whatever they did and don't have a chain of custody or reports? Is this legal? Legal, I mean, yes, it's legal, but chain of custody is not necessarily connected to reports, right? That's more the DNA itself or the sheath in the chain of custody there. But how you get to an answer in police investigations sometimes can just be discussions. Now, is it legal versus is it appropriate? And if that is the case here, I think they should at least have to produce what they do have. If it was a conversation and there's no report, obviously they're not going to have to produce that. But do you have reports? Did you build a family tree and then delete it? Because I think they should get what we call like a negative inference from that, or some kind of spoliation instruction. All right. This is taking a little longer than I expected, but we're not going to rush through it. We're going to hit as much as we need to hit. All right. Defendant's third motion to compel. What are they actually asking for? Profiles uploaded to the DNA database. Okay, and we've read through this already, but I'm just going to read the italics, which is the defense's kind of argument as to where we are. The state has provided information related to this request for the DNA on the snap. The defense has requested all DNA. See declarations. Communications. They haven't provided all the emails or text messages. See the expert declarations. Unexpected results and corrective actions. So here, this is unexpected results and corrective actions, what they're asking for. They want it for 6 months before and 6 months after testing related to the case. Only entries related to the lab personnel in this case were provided. So we'll see if they get that. And then again, the arguments over the protective order. So this is the actual third motion to compel, and their arguments kind of weaved in there with the questions. All right, next up. The declaration of one of their experts here. And I've jumped down. We've skipped a lot of her explanation of what genetic testing is and what they did in this case necessarily and what her credentials are, because I want to look through some of the specific things the state does not want to give, the defense wants, and she helps. Actually, Bicca Barlow. I don't know if that's a male or female. I for some reason I thought maybe I'm thinking like Eve Barlow. I automatically thought female. So this expert is going to help the defense say, this is why we need these specific things, Judge. From the discovery in this case, and here's what it is: match detail reports and long-form candidate match reports for the hit/hits, including partial hits and hits that are dispositioned to be non-matching, even if the lab has dispositioned a profile as a hit. From the discovery in this case, it appears that at least 3, possibly 4 profiles were uploaded to the CODIS database prior to Mr. Kohberger being charged. So that means there were 3 or 4 DNA profiles that they were looking into before charging Mr. Kohberger. And again, the state could have very appropriately dismissed the other ones, gotten alibis. They could have been the victim. There was a lot of things that it could have been that they loaded into this database to see if they got a match. Because remember, CODIS is how they're trying to connect it to see if it's somebody that's DNA that's already in their database, that's already committed other crimes or whatever. So they want to know who those people are. And I think they have every right to. Mr. Kohberger requested discovery of these uploads and any resulting hits or candidate matches to these unknown male profile, even if the lab has dispositioned them as non-candidate matches. When a profile is uploaded to the CODIS database, it is searched continuously against the database of convicted offenders and arrestees maintained by the state, generally on a weekly basis. This ensures that new individuals are added to the database, they will hit on evidence of sample profiles. And if they are deemed a match, these candidates are then forwarded directly to the lab that uploaded the evidence profile for further evaluation. The lab will then determine if the individual candidate is a candidate match or a non-match. And here's the other thing. If these are non-matches, if you did dismiss them as potential suspects, why not just turn it over to the defense? Why not show him this was the DoorDash guy? He's got an alibi. This was the victim. Cross him off. Like, I just don't know why they wouldn't provide that. I mean, I can think of a few reasons why, and I don't think it's that necessarily. The lab then dispositions the individual in the database as candidate match or non-match. All that the lab sees of the candidate is anonymized DNA profile. The disposition of a candidate match triggers the state to then provide the identity of the individual to the lab for further investigation. In the last 10 years of my practice, I have encountered a number of cases in which a database search has resulted in more than one candidate, and in which, upon court order, the anonymous profiles of the other non-matching profiles have been provided to the defense under court order. The number of non-matching profiles varies from case to case, and including one case in Santa Clara County, case number 2, whatever, and one in San Francisco County. The Hernandez case is illustrative of the subjective nature of the interpretation. In Hernandez, the lab uploaded multiple interpretations of a mixed sample to the state database. One interpretation returned 5 candidates, and the second returned 28 candidates. In Hernandez, the lab opined that 2 of the candidates could not be excluded as a source, while a defense expert reached a different opinion that 15 of the candidates could not be excluded. And there's different reasons for that, and battle of the experts, and all that happens at trial. This information was presented in trial in order to impeach the interpretation of the work done by the lab and to undermine the idea that a match by a lab is an actual identification of a single individual. That's a fair argument, in my opinion. And by the way, the reason that this expert is explaining these other cases where the court did allow this information to be discoverable and then used at trial is because courts don't like to be the first or only court to do something. And if you read the state's motion for protective order, the state kind of makes it seem like, Judge, you'd be the only judge doing this. Judges don't like that. So this expert's saying, oh no, Judge, this has been done in other cases that I've been a part of. I believe both of these experts are also trained lawyers, like they went to law school. The fact of this match made by the CODIS system is considered Brady material because it provides possible avenues of investigation of other suspects in this case. Given the subjective nature of mixture interpretation, it is reasonable to believe that other experts might disagree with whom actually is the candidate. And in this case, in which the profile at issue is ambiguous and partial, other suspects are an important area of investigation. Again, I am not saying that this is not Brian Kohberger's DNA. It could absolutely be his DNA. They have other things circumstantially connecting him to this case. The state is building a good case. But the defense should be allowed to look at these other potential suspects. And I also want to remind you that we have seen the defense mention exculpatory evidence or possibly exculpatory evidence many times in filings. So the expert here says this could be potential Brady material. The defense isn't going to say this is the only piece of exculpatory evidence we're looking for, but this very well may be what they are referencing because people are waiting for a bombshell from the defense. What do they have? What is the exculpatory evidence? What's going to prove Brian Kohberger is innocent? Well, what they could be referencing is this right here. Other possible DNA matches that they were not given information on. Maybe it is, maybe it's not. Maybe there's more. Okay, another item, unexpected results and corrective actions. Again, we've seen this reference multiple times in the motion to compel. Laboratories are required under accreditation standards to maintain logs of what are called corrective actions or unexpected results, along with root cause analysis documents for specific types of incidents encountered in labs. So if you are forced to maintain logs, you better have those logs. These logs are important, are an important measure of how the test methods are performed in the lab and also can be an indication of ongoing systemic issues as well as analyst-specific issues, both of which may be relevant to the testing in this case. Now, what's an example of this? Why do we need to keep this? Well, because there have been instances where people have been getting kickbacks from for-profit prisons to make sure DNA matches and we get them and we throw them in prison. Judges, lab people, prosecutors, whatever. This is how we found some evidence of racism in some judicial systems, where it's every time it's somebody of African-American descent, you make sure the DNA matches, and then later we find out it didn't, or we find out that this one tech has a way that they do it to make sure this happens. This is how we figure out where maybe some defense lawyers are paying lab techs, where it never matches up, or they're always part of the unexpected results or corrective actions. And because you keep these logs, you can see what system certain techs or certain law enforcement agencies or certain labs or certain courtrooms where this stuff happens. That's why we need to keep logs. And these logs should be producible in discovery. The San Francisco Crime Lab routinely produces their entire log to the Office of the District Attorney as Brady material. And this document is distributed to the defense bar. The last iteration of this document was over 100 pages. So they're saying this is how we do it in California. Now, that can cut both ways. Idaho's probably like, yeah, this ain't California. So you can keep that in California. But the point is, I think we should produce this stuff. Just give it to them. Let them look through it. What's the harm? If there's something that really is an investigative technique or undercover operation or something that's going to hinder future investigations, fine. But the other matches in this case, or even potential matches, in this case, the defense should be able to know why it's not them. Brian Kohberger has a right to know why it's not Jim, John, or Bob. All right, a couple more questions before we get to the next expert. What is the difference between touched DNA and DNA? I am confused. So if you have like spit or blood or whatever, and you test that DNA from bodily fluids, that's the DNA. If you can get touch DNA by like skin cells, like I touch my phone and then I put my phone on this table. Well, this table right here now has touch DNA on it, but I never even touched the table. So what does touch DNA really mean? It doesn't even mean you touched the object where the DNA is there. I can also touch you, Azam, shake your hand, and then you go and pat somebody on the head, and now my touch DNA could be on their head, and I never even saw or met that person. So touch DNA is not the same thing as if I, cut and I bled on somebody, and so my blood is on somebody. It's like, okay, that's my DNA on them. I mean, it's kind of gross that I'm using these examples, but to try to give an explanation, we're going to talk about this more as the case goes on. Unresolved crimes. What if the state cannot show their records for the lead that led to the familiar tip? Then the judge is going to have to determine, was there any wrongdoing or fraud, or do you allow the defense to argue the state destroyed records, or the state doesn't have these records and they should? And then the jury has to say, is the state doing something wrong, or the way the state explains it, that they just don't keep records of that, is that reasonable? And it can be a jury question. We put a lot in the hands of a jury in these situations. Tori, we can't assigning guilt or innocence by just motions. We need to see the trial and all the evidence. Thank you, Peter, for the way too early morning live at 6 a.m. here. Glad you're going over these motions. I'm glad you're here too. And yes, we are absolutely reserving judgment on what we think the final result is going to be in this case. But at this point, I want the defense to get this information because I want to be sure at the end of this trial we got the right guy. And if there's potentially here's the point, they could be nothing. But as long as the defense has the argument that they're not showing it to us, we have to sit here and think like, is this bad? I mean, people are saying, oh, the state's hiding things. I don't think the state's hiding things, but I think they should produce it so we can cross them off and move on. Daria, prosecution focus should be to find the truth, not to win a case. I agree. And I am not sitting here saying the prosecution's trying to win the case and not caring about the truth. I think they're seeing what the law allows. They're trying to not give up stuff they don't have to, but if the court says to give it up, and let's make sure everything was done above board in the right way. I don't necessarily think we're going to find that there's any like wrongdoing on the part of the state here. I really don't. All right, let's bring up our second expert declaration here. Stephen Mercer, I'm confident that I can call him Mr. All right. Let's increase this. And again, I've skipped down to kind of some of his analysis, and we've skipped his credentials and stuff as well. And this is basically coming from him, but this is an argument to the judge from the defense team. Okay. It is a minimum practice standard for defense counsel's investigation to obtain discovery of DNA testing of evidence, regardless of the prosecuting authority's decision to offer the DNA testing results as evidence at a hearing or trial. That's obvious. Just because they're not going to use it doesn't mean we don't want to use it, Judge, right? How often do we see that in cases? The minimum practice standard for investigating DNA evidence is rooted in the ABA standards for criminal justice, Defense Function Standard 441, which outlines the general responsibilities of a criminal defendant's trial counsel regarding the duty to investigate. It states, defense counsel should conduct a prompt investigation of the circumstances of the case and explore all avenues leading to facts relevant to the merits of the case and the penalty in the event of conviction. The investigation should include efforts to secure information in the possession of the prosecution and law enforcement authorities. The duty to investigate exists regardless of the accused's admission or statements to defense counsel of facts constituting guilt of the accused's stated desire to plead guilty. So again, a lot of you have asked me questions like this. Do you still do this investigation if they tell you they did it? There's your answer. Answer is yes, according to the American Bar Association. All right, what else do they say? Well, the ABA has promulgated a set of criminal justice standards on DNA evidence in 2007 that requires the pretrial production of DNA discovery. And again, defense attorneys have to do this. They should do this, or it could be ineffective assistance of counsel if you're violating the ABA rules for criminal defense attorneys, for criminal justice. Actually, criminal justice is not just criminal defense. Criminal justice is both sides. The prosecutor should be required within a specified and reasonable time prior to trial to make available to the defense the following information and material relating to DNA evidence. Lab reports as provided in Standard 3.3. If different from or not contained in any lab report, a written description of the substance of the proposed testimony of each expert, the expert's opinion, and underlying basis of that opinion. At this point, I believe, based on the way the state's writing things, they don't have an expert or expert report yet. So that's why that might not have been produced. A CV for each testifying expert, the written material specified in the Standard 3.1, reports of all proficiency examinations of each testifying expert, what the expert did, the chain of custody for the documents, specified in Standard 2.5, all raw electronic data produced during testing, reports of laboratory contamination and other laboratory problems affecting testing procedures or results relevant to the evaluation of the procedures and test results obtained in the case and corrective actions taken in response. That seems to be right on point with what the defense is asking for. A list of collected items that there is reason to believe contain DNA evidence but have been destroyed or lost or have otherwise become unavailable. Material or information within the prosecutor's possession or control, including laboratory information or material that would tend to negate the guilt of the defendant or reduce the punishment of the defendant, which the state would argue they've turned all that over. The defense would say they have not. But that's straight from the ABA saying why we need this stuff. The minimum practice standard for a competent defense counsel to obtain and review discovery applies to forensic genetic genealogy DNA testing. So he is saying these apply to what the defense is asking for, and you should give them to the defense. So that's what I wanted to read, was the ABA guidelines here from this expert. All right. And the last document we are going to read together is going to be the Jay Logsdon's objection to the state's motion for protective order and an explanation of how the defense sees this case, what issues the defense sees in this case, and where we go from here. First, I'll answer a couple questions. Mercy Cat, why wasn't the sheath found by the initial law enforcement? I don't know. That's something we're going to find out in depositions, I would think. Was Kohberger just the easiest to frame blame of all the men? Also, cross-contamination. If shady prosecution has nothing to hide, then hand it over. So it's not like they have to hand over everything, but I do think that they should hand over this DNA stuff because it could absolutely be relevant. It could absolutely point to somebody else. Also, a lot of this information I think is going to come out in depositions. That's why we do discovery. We get documents, but we need all the documents first as lawyers before we take the depositions. Because if a law enforcement officer lies or a witness lies or is inconsistent, then we have the documents to say, well, they said the sheath was found here. You just testified you found it in the bathroom. And that could be a big moment. Chrisia, so far, what grade would you give the defense team? So this is hard because I don't know what they have. I don't know what they know. I don't know what they don't know. I don't know what Kohberger is saying. But from the outside looking in, they are absolutely doing everything they can to fight for Bryan Kohberger and zealously represent him, regardless of what the public thinks about Bryan Kohberger, regardless of what the public thinks about them, regardless of what the state thinks about them, regardless of what anybody thinks about them, which is their job and what they're supposed to do. So I would give them an A at this point, based on what we know. I think they are doing their job. And they are trying to gather everything they possibly can. All right. Let's get here to the objection to the state's motion for protective order. The last document for this morning's live. All right. So get your questions in now if you have them, and I'll answer some more for a few minutes after we're done with this. Comes now Kohberger's attorney, and they file this objection on the grounds that the material the state seeks to hide is discoverable and must be provided to Mr. Kohberger. Whoops, it's not up on the screen. That's my bad. All right. So we're going to start off with a bang here, and this is, again, linguistic differences. But he says specifically The state is seeking to hide discoverable material. What's interesting about this is by using this kind of language, you are absolutely calling out wrongdoing by the state, which is fine if you believe that to be true and you have a good faith basis to do that. Some lawyers would take issue with this. Some judges would absolutely take issue with this because what happens if the judge agrees with the state that this is not discoverable? I may disagree with them. The defense attorneys may disagree with them. People in the chat may disagree with them. But are you now saying that the judge is hiding discoverable material? Because that's misconduct. That's sanctionable. That could potentially make you lose your license if you're hiding things you know are discoverable. You can do it if you believe it, but you better believe it. Factual background. On November 13th, 2022, law enforcement responding to a 911 call found Madison Mogan, Kaylee Gonsalves, Anna Kernodle, and Ethan Chapin deceased. Law enforcement later found a K-bar knife sheath placed next to Miss Mogan on her bed. Placed. So this to me is one of the first times we've really gotten an explanation of what happened from the defense. And I am not going to say the defense is violating any privilege, attorney-client privilege, or anything like that. But we do know defense attorneys talk to their clients. Do we have any of Kohberger's statements or Kohberger's versions of the story in here? Or is it just what his lawyer knows from reports and talking to experts and reading police reports and looking through documents that we've never seen? Hold on one second. But now we're getting into some of the defense's view of the facts of this case. And the word placed might make you think Kohberger thinks he was framed. That some knife sheath that he touched at some other time was taken by somebody and placed at the scene in order to frame him. More on that later. And we don't just say the sheath was placed once, but twice. The sheath was placed button side down and partially under Miss Mogan and the comforter. On November 20th, the Idaho State Police Lab in Meridian, Idaho, located DNA on the bottom of the sheath and performed STR analysis that led nowhere when ran through CODIS, other than to show the provider was male. Somebody asked, why are they focusing on male DNA? That's why. By December 17th, 2022, once they found out it was male, when they started connecting it elsewhere, they were focused on males. By December 17th, 2022, lab analysts were aware of 2 additional males' DNA within the house where the deceased were located, and another unknown male DNA on a glove found outside the residence on November 20th, 2022. Now, if you found a glove in Florida, I don't care if it's November or what month, that would be weird. And maybe that's somebody breaking in, and maybe that's somebody doing something that they want to hide their fingerprints. But in November in Idaho, my guess is a lot of people wear gloves. So that's 2 or 3 additional male DNAs in the mix here, right? Which again could be absolutely nothing, but we got to get that answer. And I don't just like the law enforcement of the state saying, trust me, they're not involved. To this date, the defense is unaware of what sort of testing, if any, was conducted on these samples other than the STR DNA profiles. Further, these 3 separate and distinct male DNA profiles were not identified through CODIS, leading to the conclusion that the profiles do not belong to Mr. Kohberger. While this was ongoing, police were investigating many other possible suspects, and they can say that, and we can sit here and say, oh, there were all these other suspects, but we know there were thousands, if not millions, literally, of tips that were going through tip lines and being emailed in and called in. So it's not a stretch to think there were various other suspects. I mean, we know the TikToker that's being sued that was so sure it was the professor. Many of them provided DNA. At least one had his DNA surreptitiously taken from a discarded cigarette. Many also had their phones taken and downloaded. So were they investigating people that had partied there and had hung out there and friends of the victims? Again, a connection would make sense. Ex-boyfriends of the victims. One area of the investigation had to do with a white sedan seen on a camera located at 1112 King Road, first glimpsed by officers on November 18, 2022. By November 25th, police believed the car to be a white Elantra and asked law enforcement to be on the lookout for one. Precisely how the police came to believe the car was an Elantra is still unknown. A report from an analyst for the FBI dated March 21st, 2023 shows the analyst heavily relying on a video of a car heading in the wrong direction and at the wrong time on Ridge Road. Again, they're pointing us to holes that are being poked in the state's case that they plan on poking. Which is why anytime we just read a probable cause affidavit or something filed by one side or the other, you always want to hear both sides and how they look at it, because a jury is going to have to determine who's right. The state's latest filing admits that somewhere within all of this, they engaged in investigative genetic genealogy using the DNA from the button on the sheath, and now claims that it was due to the use of this technique that it tipped local law enforcement to investigate Mr. Kohberger. It remains unclear what the police first relied on in focusing their investigation on Mr. Kohberger. No matter what came first, the car or the genetic genealogy, the investigation has provided precious little. There is no connection between Kohberger and the victims. So that statement right there, to me, is one of the more important ones. Because for the defense to say that confidently in a filing, that means they're pretty confident that it's true. But I will say, there are times in every case where one side or the other will say something that they believe is true, and the other side will actually have a document, a witness, testimony, something, a social media post that will actually provide a connection. And we never hear about this again. And it's like, oh, well, we thought they didn't have a connection at the time. But as we sit here, we have not heard a single connection. We've heard some, like maybe he said some things in messages on social media. I would call that a connection. So is that even true? I don't know. Where were we here? No connection between Kohberger and the victims. There is no explanation for the total lack of DNA evidence from the victims in Mr. Kohberger's apartment, office, home, or vehicle. So this is something, no connection, I think, is a broader term, right? Because like if he even had looked at their social media at some point, that could be arguably a connection. But no DNA evidence in his home, office, car, connecting the victims to him, no DNA, apartment, office, home, or vehicle. That's significant. We know there's cleaning materials, right? And they're going to explain it with that. But in other documents, they said there's no explanation for it. So having no DNA evidence, right, to be able to get rid of all touch DNA, blood, bodily fluids, in a crime scene that's been explained to us as messy, I'm shocked. Because you can't say at this point, well, he drove another car, or there was some this or some that. Because the white Elantra is how they connected him there. So the car is the big piece. We know they cleaned it, but did nothing seep through the carpets? He didn't miss a single spot where it was everywhere? They didn't find any clothes. Was he wearing, was he wearing a certain outfit and then took it off and bundled it up perfectly? That's a really tough one for me. And we know he, stopped places and, drove this other route that if it was him, he could have ditched the clothes or the knife or whatever. But to me, that is really wild. And then we can't argue out of both sides of our mouth because he perfectly cleaned up his car. He made sure that none of his touch DNA or sweat or anything ended up in the victim's house or in his own car, apartment, everywhere else, except he dropped the sheath that was covering the weapon he used to commit the crime and just left it there. That to me is it's not impossible, right? Absolutely that could happen. Criminals make mistakes all the time, and thank God they do. But to commit the perfect crime and then also be pretty unsophisticated in how you got caught, something the state's definitely going to have to reconcile. They really will. And I think they have a lot of evidence, and I think the state's going to be able to put a lot of circumstantial evidence forward, which is why I want them to produce this stuff to the defense. So if there's anything there, we can find out about it. All right. In essence, through the lack of disclosure and their motion to protect the genetic genealogy investigation, the state is hiding its entire case. I disagree. I can agree with the defense sometimes. I can disagree with the defense sometimes. That's going to happen. Same thing with the state. I agree sometimes. I disagree sometimes. I agree with him. That's absolutely wild. No connection to the victim and no DNA. Do I think the state is hiding their entire case? Absolutely not. Which is why I don't like making statements like that generally, in case you haven't noticed, because you guys have heard me say a lot of statements. All right, let's get to his argument now. The state apparently thinks that they need not explain how they came to think that it was Mr. Kohberger's DNA on the sheath. I disagree with that as well. Presumably, the defense is expected to accept at face value that the sheath had touch DNA just waiting for testing by all the FBI's myriad resources. Additionally, the defense is to guess whether the state focused its investigation on Mr. Kohberger via a bizarrely complex DNA tree experiment or through its faulty identification of the vehicle involved in this case. I mean, really some hyperbole here. Their faulty identification of the vehicle involved in the case. Is he talking about the year? Is he talking about the video where it's going the wrong way? This, I think, is a little too far down the road. I do think that they need to turn over how we got here. And I don't think we should accept anything at face value just because the state or law enforcement says it. So I agree with him there. Perhaps unsurprisingly, Mr. Kohberger does not accept that his defense does not need this information. It rather obviously falls within the ambit of Rule 16b4 and 5, a fact the state's briefing makes clear in its kitchen sink approach to their briefing. The state begins their argument claiming Rule 16 has no interest in IgG testing, and then ends their argument claiming that somehow people will stop sharing their genetics if they were to realize the government is watching. Both arguments must fail. To begin with, the state apparently only wants to prevent Mr. Kohberger from seeing how the IgG profile was created and how many other people the FBI chose to ignore during their investigation. In essence, the state argues that if the later STR testing is accurate, then there is no reason to concern ourselves with how the state came to investigate Mr. Kohberger. The state's brief at 9. What the state's argument asks this court and Mr. Kohberger to assume is that the DNA on the sheath was placed there by Mr. Kohberger and not someone else during an investigation that spans hundreds of members of law enforcement and apparently at least one lab the state refuses to name. That's the touch DNA problem, right? If it was Kohberger's blood on there, that's different than touch DNA. Especially maybe that's how we're going to get some criminology connections or application to Kohberger. Maybe he shook one of the officers' hands earlier that day. I don't know. Perhaps most puzzling is the state's argument that while Rule 16b5 requires them to turn over results or reports from scientific investigation, it does not require the state to disclose what law enforcement does with the results of the reports. First of all, that sounds like an admission that the information as to how the IgG was carried out should be disclosed. Second, what law enforcement does with the results or reports is covered by Rule 16b6, statements of the prosecution witnesses and police reports. Frankly, the fact that members of the FBI are so concerned about permitting Mr. Kohberger to know what they were up to with what was supposedly his DNA does not give him one impression that there is nothing to see here, as the state seems to imply. I agree. That's not usually a good enough argument. Finally, the state's claim that ICR 16G2 applies to this matter is quite bizarre. Presumably, the independent company the government relied on was paid for its work and would stand by it in court. The state provides no real argument as to why the company needs to be protected. Mr. Kohberger is left to suspect they wish to keep their methods from being questioned. To the extent that there is some concern about intellectual property, that can be addressed via protective order that permits Mr. Kohberger and his defense team to review their work. I 100% agree with that. We don't need to give out anything proprietary. Just let us look, and if you did it wrong, we're going to blow a hole in it. If you did it right, it is what it is. Second, the state appears to argue that everyone living on Earth that provides genetic information is A, unaware that their DNA could be used by a government somewhere for something, right, which is not true. People realize that at this point, I think. And B is an informant within the meaning of the term and the rule. And that is absolutely false. They are not informants within the meaning of the rule, in my opinion. The state citations to cases involving actual informants hardly help it make this incredible leap. Again, and we talked about this, what the difference is between an informant that does something and what we have in this case on the last video. No court has ever found the existence of a DNA informant. It would appear that the state is acknowledging that the companies are providing personal information to the state and that those companies and the government would suffer if the public were to realize it. The only two databases that allow access are ones that already inform their users, and those users can opt in to allow law enforcement searches. The statement by the government implies that the database searches may be ones that law enforcement is specifically barred from, which explains why they do not want to disclose their methods. If the fact that the government is looking at the genetic information that people are sharing was at all an issue, the state's very public acknowledgement of such investigation was clearly a big mistake. So again, if people said, no, the government can absolutely not get this information, and the government went and got it, now are we having certain fruit of the poisonous tree issues? To be determined. In any case, it is hard to understand why Kohberger should be the one to suffer because these companies and our government choose to either mislead or not educate the public. According to the Pew Research Center in February of 2020, 48% of the respondents thought it was acceptable to give their data to law enforcement to solve a crime. 33% said no, 18% were unsure. However, 60% thought that their genetic information could not be shared with other companies. There is no federal law about sharing of genetic information, but multiple states have begun regulating police use. Mr. Kohberger has now, being shady is different than breaking a law, right? Doing things the public doesn't know that law enforcement is doing is obviously allowed. We see it in every case. And if that's what we have here, it's not going to be fruit of this poisonous tree. But if they broke laws, obviously that's how we get there. Mr. Kohberger has reasons to be extremely suspicious of the IgG used in this case. Again, this is leverage. I don't think necessarily they're saying everything we're saying is a fact that's proven by the evidence. Like, they're not saying we know something fraudulent's going on, but they're using the unknown as leverage with the court as a tool in their tool belt to say, give us this information. We have to have this information, or else this is not a fair trial. And they're protecting the record here over and over again. Rather than seeing it as some sort of complex tree building that led to him, it appears far more like a lineup where the government was already aware of who they wanted to target. So they have a tree and it's like 20 males. And they're like, well, we know Kohberger has an Elantra, so let's go with him. Because we don't want to go with this person who doesn't have an Elantra, even though their DNA was there too, because we have no other circumstantial evidence to connect them. Now, maybe that's okay, because you have to build the whole picture. But the defense needs to look and say, well, did you know about this? Did you know he used to date her, or they went to high school together, or they actually have connections with the victims that you all didn't investigate enough? That happens. Those arguments are made. They were made in Murdoch. They're made in Melly's case. Rather than have the investigation done by someone blind to that fact, the FBI chose to do it themselves. This is akin to the police pulling in Mr. Kohberger and 5 of his cousins off the street and then pointing at him. The only authority the state has in its favor that is on point is a trial court order from a California case that settled before it could lead anywhere. The decision relied on in People versus Johnson. The court in Johnson was not deciding whether a defendant had a right to know he was identified, only that his identification could come in at trial without a mini trial about it. A better case on the issue is State versus Ortega. In this case, an appellate court heard similar arguments about the need for software used for facial recognition to be discovered for the defendant, though they would not be admitted at trial. The court, when considering this matter, found, we are keenly aware The cases we have discussed involved instances concerning Fry hearings, which is like Daubert on experts, and potential expert testimony. And that here we are dealing instead with eyewitnesses who have already identified the perpetrator and the identification found admissible under Wade. However, the facts of this case convince us the defendant will be deprived of due process if he does not have access to the raw materials integral to building of an effective defense. The evidence sought here is directly tied to the defense's ability to test the reliability of the FRT. As such, it is vital to impeach the witness's identification, challenge the state's investigation, create reasonable doubt, and demonstrate third-party guilt. Again, this is kind of where I land, is where this case is saying. Not that it's all going to happen, but that they should have access to the material because it could lead to one of those things. The FRT's reliability has obvious implications for the accuracy of the identification process because an array constructed around a mistaken potential match would leave the witness with no actual perpetrator to choose. The reliability of the technology bears relevance to the quality and thoroughness of the broader criminal investigation and whether the potential matches the software returned yielded any other viable alternative suspects to establish third-party guilt. Defendant's request for the identity, design, specifications, and operation of the program or programs used for analysis and the database or databases used for comparison are relevant to FRT's reliability. At trial, the state will likely have their investigating officer explain the police investigation, including the process of retrieving the still photo from the surveillance camera ultimately used to generate an image of the defendant. Although we do not speculate regarding the exact nature of the testimony and whether the defendant will seek to impeach it, the fact that the state does not bear the burden of adducing testimony regarding the comparison of the photo array does not bar the defense access to the discovery sought. I think that's a very good analogy to this case. Mr. Kohberger finds himself in a similar position. A massive investigation came to focus on him and him alone. The state appears to be trying to hide its original domino such that he cannot discover why. Mr. Kohberger has a right to discover and question the investigation that led to him, and the court should find so. So again, that doesn't mean that whatever he finds is not going to still point to him. That also doesn't mean if all these arguments are made to a jury looks at what the state and law enforcement did in this case and said, makes sense. I agree with what the law enforcement did. All right. Azam, another question. You said the prosecution holds all the cards. How does the judge determine which evidence to give to the defense? It's a good question, Azam. It has to reasonably be believed to lead to discoverable material. So anything that can be used to lead to something that could be relevant to the trial. And discovery should be broad. KH, welcome to the membership crew. The Sweet P, Kathleen, and Deborah, welcome everybody. Candy Girl, thank you for the super sticker. Let's get to some questions here. Ciara, Lovebug. Hi, Peter. Thank you for covering this. What are your overall thoughts on this case as things stand right now? Is it really possible that BK would be able to clean his car and apartment so well that there is no DNA? Is it possible? Yes. I would be surprised, and I would hammer in, if I was the defense attorney on cross-examination, to any state witness that says that. Be like, explain to me how he would get rid of all the blood and all the DNA. Yet he couldn't get rid of it on the knife sheath. Those are kind of the arguments you make at trial. Martha, did they take the DoorDash driver's DNA? I don't know. That's something that I think the defense should know, though. Unresolved crimes. To add insult to injury to this document, the defense will argue how it came to be that an ex-detective found that glove outside in the first place. Hence, how reliable is this investigation? Unresolved crimes. You're absolutely right. Those are going to be things that get picked apart throughout the entirety of this investigation. Absolutely. Bad Wolf. Peter, does the defense have a duty or obligation for candor? Can they be sanctioned for misstating anything that they have discovered in their review of the evidence? They absolutely have a duty of candor. They can get sanctioned or reprimanded if they lie to the court. Now, if they don't have something, so they say it doesn't exist, and then the state later produces it, there's nothing wrong with that because they didn't have it at the time. If they looked at something and in good faith made an argument that turns out to be wrong, they could be sanctioned, but probably not. As long as you act in good faith. Krissa, retired homicide detective found the glove outside that the police missed. Possible same one referenced. Would that complicate things for the prosecution? Anything they miss in an investigation complicates it. And that's why the defense, sometimes they stack a bunch of mistakes up. It's not just one big mistake. We literally heard this in opening statement from Ellie, if anybody's watching and following that trial. They made so many little mistakes that we got to throw this whole investigation out, basically is what they said. Tina, Peter, a very interesting topic here. Great coverage as always. Finally, it's been a while. I've made a live, late but here. Thank you, Tina. And I know Tina throws a lot of questions in the DMs on Instagram, and I try to hit a lot of them, and I work them into the streams. So a lot of the content, thank you, Tina, for those questions. Okay. Question. Do you think seeing a defense like this implies they think BK is innocent? Oftentimes it seems like the defense in these cases seems a bit defeated in their advocacy. I think it's just a better defense to go forward like this without saying anything Kohberger is saying versus what we saw in Stock or Lori Vallow in those cases, my opinion. And they are arguing at this point that it seems like they think it points to somebody else or that they've got nothing on Kohberger. They're not picking one. They're definitely saying we don't think you can prove it was Kohberger. And then they're also saying we think that there's going to be potentially other people we can point the finger at. Tori, does BK have a public defender or is he paying? I forgot. Is this a death penalty case? They haven't filed the notice of death penalty, but we think it is. And other people have said they all expect that to be the case. It is a public defender, but is the public defender and death penalty qualified. She's got another lawyer with her that's death penalty qualified. Mama Rebel, Peter, if the case is weak, is it more likely the state will not go for the death penalty? I think they are going to go for the death penalty at this point because of the media attention. They can always withdraw it later. So I expect them to file a notice of intent to seek the death penalty here. Azam, if the prosecution has the wrong person, I'm not saying that they do they have to start their investigation from zero? No, but they have to dismiss the charges against Brian Kohberger, and it does get a lot more difficult to go after the second person. They don't have to start from zero. They can use evidence they already have, but it's very difficult. Sorry. I thought that the state had to hand over everything in discovery. How wrong was I? Yes, they definitely do not have to turn over everything. Star, Peter, in your opinion, what do you think about how this is written? Why isn't the state investigating the other male DNA? And did they admit to drawing a family tree to get BK's name? I think they did admit to a tree, but they absolutely did not admit that they didn't investigate the other DNA. I can almost guarantee they're going to say we did investigate and dismiss them as potential suspects, the other DNA. Because again, it could have been friends or a victim or the DoorDash guy or whatever, the dad. It could have been one of the victim's dads that was there for, parents' weekend a month before and his DNA was on the glove outside, whatever. We don't know. I think they have investigated it, but what I also think is the defense has a right to know and investigate it as well. What do I think about the language? Again, I think I mentioned that off the top. It's not exactly how I would do it, but a lot of lawyers do it this way. There's nothing inherently wrong about it. I also think that all the lawyers in this case know the public is reading and looking at these documents. Ciara, welcome. And self-aware. Tori, sometimes murder happens for no reason and no connection, i.e. the Hillside Strangler and people like that, right? Sometimes connections can't be made and there is no reason. Absolutely. Which is why you do not have to prove motive, because sometimes people do unexplainable things. And that is a great point. How likely is a high-profile trial with precious little evidence? Well, Misbehaving, I would be willing to bet that the state does not think that they have precious little evidence. So, that's the point, is each side's going to disagree with how they view this evidence. Thank you, Jennifer Wiggs. Tori, is this the only time BK sent people to heaven? I don't know. I don't even know if he did it this time, right? Sonia P, thank you for the super sticker. And Jennifer Wiggs, thank you for the super sticker. Sonia P, Peter, were they questioning if there was a lineup and if it was done correctly? They were analogizing it to a lineup, but they were saying like they built a family tree and then looked at who it could be, kind of like when you see a lineup and you try to figure out who it was that you recognized and you saw commit the crime, but they already had Kohberger in their head. So they made sure his DNA fit, just like if you have one person, one male and 5 females in a lineup. It's like, well, the guy is who I saw do it. Or one person with blonde hair, everybody else with brown. And it's like the guy who did it has blonde hair. Kind of like that, rigging a lineup. Jennifer, is the state protecting an anonymous source, family, friend? It doesn't seem like that at this point. It seems like they're saying everybody whose DNA is in the system is technically an informant, and we don't want to let their information out there. They are not the same definitionally as criminal informants who have certain protections. Now, the court could say, because again, technology and things advancing, I would expect rules to be written on how we deal with this stuff. Like we try to write rules thinking for the future, but we're always behind because we don't know what technology is going to come out and provide for us. So I don't know that they're specifically saying that at this point. All right, I have to go. This has already gone longer than expected, but I'm glad we got through this first part. Second part with media and cameras and all that stuff coming later this week. Hopefully you guys enjoyed it. Hopefully I was able to answer at least some of your questions. Hit that like button on the way out, and we will go out with Nicole Mobley's post. Hope everyone is doing well as always, and thank you for the update, Peter. Hit that like button on the way out. Subscribe if you haven't. We might hit 250,000 subscribers this week. And like 40-something% of people watching this video right now are not subscribed. So hit that subscribe button for me, and let's try to get to 250K. All right. Much love to all of you. I'm out of here. Let's hit the outro. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.